Order list kora ase ni order karne. Ah. There are deposits made into this account from outside. That's why the hold is put.
Fraudulent transaction was there.
That transaction. You have not explained how this money has come into your account.
One person, my lord.
No. How can an unknown person? Some money is being deposited into your account. So how did they get that account and how did they withdraw that money from your account? 3 lakh odd is pending now.
But some money was deposited to my account and thereafter, my lord, again withdraw the same. In addition to the amount deposited, my lord, additional 92,000 also taken from my account.
Okay. Mr.
M. Hussain, my lord.
His FIR. I know that. Mr. M. Hussain, learned counsel for the petitioner, submits that the arguing counsel, Mr. S. Dr. Learned senior counsel, appearing for the petitioner, is out of station today and is not in a position to appear before this court, and accordingly prays that the matter be adjourned today. The learned counsel for the Mr. A. Parvez and Mr. A. Parvez, Mr. P. Hazurika and Mr. S.S. Roy, learned counsels appearing for the respondents, have not objected to the said prayer made by the learned counsel for the petitioner. Accordingly, the registry to list this matter after the ensuing puja vacations on a date to be fixed by it. Not possible before that. This will have to be heard.
God bless.
Item number? Why? Your senior is? Your senior? Oh, that land acquisition matter. You have objections. You have no objection. You have no objection. Okay. Heard. Mr. Arboro, learned counsel. A prayer is made on behalf of Mr. C. Borua, learned counsel of learned standing counsel NHAI for an adjournment in the matter on account of personal inconvenience. Prayer is not objected to by the learned counsel for the petitioner. Accordingly, a registry to list this matter on 16/10/2025 for hearing.
Your Lordship, I beg to mention item number 13.
30?
13, 1-3.
1-3.
Have the consent from the other side, Your Lordship, Mr. M. Sharma. Lordship, in case counsel is having a laryngitis, Your Lordship.
You are appearing for?
K. Sharma.
Okay. A prayer is made on behalf of Mr. P.K. Sharma, learned counsel for the petitioner for an adjournment in the matter on the ground that he is indisposed. Prayer is not objected to by the learned counsel for the respondents. Full stop. Accordingly, registry to list this matter again after the ensuing puja vacations on a date to be fixed by it. Yes, ma'am. What is there here, ma'am, in this case?
Lordship,
Fine. What right of yours have been violated? What right of yours have been violated? The ad hoc committee is also, I think, not a party here. But be that as it may. A prayer is made on behalf of Mr. P.J. Saikyal, learned senior counsel, for an adjournment in the matter on the ground that he is not in station today. Registry to prayer accepted, registry to list this matter again on 22/9/2025 for hearing. Yes, Mr. Tapadar.
Same prayer, my lord. Sin,
I'm sorry, we are not
my lord,
adjourning this matter.
Only,
I'm sorry, this matter was adjourned on your account.
yes, my lord.
So we are not adjourning
My
this
lord,
matter.
only my folded hand, my lord.
We are no folded hands, Mr. Tabata. You make your submissions. We had specifically
Yes,
recorded in the last order
My lord,
that this matter is adjourned because you are not keeping well.
I'm still not feeling well.
Okay, you start. We'll try. You start.
In a request, my lord. Fine, my lord, because I am not.
Why didn't you not circulate a memo yesterday?
Yesterday, my lord, because they have come to. Only
We'll see. Let the matter be called up. We'll see.
Yes, madam.
Yes, madam.
So last week, let's go back to
8. Hmm. No, we are not adjourning the matter. We are not.
color number.
And where you do, have you informed the petitioner? Where is the communication? Where is the, ma'am, we are not going to allow this matter to remain like this. Let the matter be called up, make your submissions then. Submits that the arguing counsel, Mr. A.S., is not in a position to appear as he is indisposed. Mr. Uddin has made his submissions in the matter. However, he submits that further submissions in the matter would be made by Mr. A.S. Tapadar. So, Mr. A.S. Tapadar is very much before us. Why will we not take that opportunity to hear him? We have no apologies. You argue.
Client,
Who is there for the forest?
I have taken concern, even Mr. PJ, even their concern, my lord. As the last opportunity, my lord, on 9th, my lord. Expectful prayer, my lord. As a last opportunity.
Not accepted, Mr. Tapadar. This sort of behavior is not accepted.
My sincere apology, my lord, only on the interest of the client, my lord.
There is no interest here. We can pass orders if you want just now.
But in presence,
I gave you an opportunity to make your submissions.
my lord, my
This is too much beyond what can be.
Yes, my lord. My sincere apology, my lord, only for a last opportunity, my lord, to accommodate. Please release the matter on 9th, my lord. 9th, my lord.
We are doing it on Ajike Mantari,
9th,
we are doing it on 5th.
9th, my lord. He's out of station, my lord. Only
He'll
that,
come back on 4th.
my lord. My learned friend, double check with them, my lord. So, request on 9th, my lord. As a last opportunity, my lord.
Although on the last occasion, the prayer was made that the matter would be full stop on the last date of listing, that is on 18/8/2025, a prayer was made on behalf of Mr. A.S. Tapadar for an adjournment in the matter on the ground that he is the arguing counsel and was indisposed. So today, when the matter is listed, Mr. A.S. Tapadar has appeared and made a prayer that the matter be adjourned as the petitioners have engaged a senior counsel. So the said development was not brought to the notice of this court by way of circulation of a memo seeking adjournment of the matter. So, however, for the ends of justice, registry to list this matter again on 16/9/2025 for further hearing. It is made clear that no further adjournment in the matter would be granted.
I'm deeply obliged, my lord.
सबसे पहले मैं पास
Yes, Mr. Sharma, you have not filed an affidavit in terms of the orders passed by this. No, there is a specific order here. 16/6/2025. So you are saying that the impugn order is bad, we'll have to interfere with that. If that is your submission, I have no issue. Then That is why you have been asked to file an affidavit, whether this thing was done under 12 or not. But make a statement to that effect. That will be the end of the matter. If you come to the, Mr. Sharma will not go in. This is after hearing you. In the aforesaid backdrop, this court is of the opinion that the affidavit filed by so-and-so is not sufficient for adjudication. Therefore, a detailed affidavit is required to be filed clarifying under what circumstances the impugn order is issued, as well as whether the aforesaid order was an approval / direction to the collector, that is the Deputy Commissioner so-and-so, in exercise of its powers under Section 12, read with so-and-so, and whether Saldhua Pukuri, Tinsukia is a listed archaeological should be site in terms of the Act of 1959 and the rules. But you have been thereafter taking time, you have not. So if you are not filing an affidavit, we'll record it and we'll proceed with the matter. Then how do I get over with this? How do I get over with this? This is a specific direction to you, Mr. Sharma.
To be shown in the
Only thing is that they'll have to file an affidavit to that effect, just explaining that position. We'll take care of the rest. Okay, Mr. H. Sharma.
after the vacation.
Mr. H. Sharma submits that the affidavit directed to be filed in the matter, while order dated 16/6/2025, would be invariably filed on or before 22/9/2025. No. Before that once. Within 22/9, you file your affidavit. We'll have it. Much time is there? 20 days are there. The petitioner shall thereafter bring on record his rejoinder thereto on or before 26/9/2025, registered to list this matter again on 14/10/2025.
No instruction from the PNRD. No instruction from the respondent side as well.
Very good for you. You establish your case. Mr. Dutta, you continue to not have any instructions.
The name of penalty is
This is a case wherein they had made some construction in a bi-weekly market, Batodrova Ansolik Panchayat. So that was directed to be demolished. What is your stand on this?
Stay order was operated. Right order dated 22/6/2018. The impure
22/6?
22/6 of the.
That is in this proceeding.
Yes, Lordship.
14/6.
Lordship.
14/6 was stayed.
Yes, Lordship.
Then what happened?
So, Lordship, these are basically very poor economic people, Lordship. They have been given temporary settlement, Lordship, in the market. And they were
How can they have a temporary settlement in the market?
by the existent lessee, Lordship, who was present at that time.
That lessee
They
will
have-
change.
they- Yes, Lordship. They
Then
have changed, Lordship. But
Your thing is also
on
gone.
a regular basis, whoever came, Lordship, after them, they have been given duly.
Why have you constructed a structure there?
Structure was always there, Lordship. These are not a concrete structure, Lordship. These
Dinner
are,
as it may.
these are Lordship, small shops, Lordship, pan shops, Lordship, chicken shops. This doesn't require a big place,
Okay.
Lordship.
Mr. S. Dr.
this located. It's any only some sort.
Mr. S. Dr. Learned Counsel for the petitioner submits that it is only on the listing of the present matter today that he has come to learn about the pendency of the same, in as much as copy of the writ petition, nor A copy of the writ petition was not furnished to him. Also, in view of the above position, he prays that the matter be taken up on 17/9/2025, on which date he shall complete his instruction and apprise this court of the stand of the respondent in the matter. Full stop. Prayer accepted. Registry to list this matter again on 17/9/2025. Interim order passed earlier to continue.
On the petition.
From the continue till the next date of listing. Learned counsel for the petitioner to serve a copy of the writ petition along with its annexures to Mr. S. Datta during the course of the day.
Hello.
Have you paid the money, deposited the amount? Why? Two o'clock. Mr. Roy, 2 o'clock. Where's Mr. Saraf, Dr. Saraf? How long will we keep Mr. Saraf waiting? That tender, NHPC. The Chaudhary was to make the submissions. Where is he? Time me.
Already completed our arguments, Your Lordship.
You have, but he was supposed to. Yes, what is your? Huh? Huh? Where is Mr. B. Gugoi? Okay, time being. Yes, Mr. Swekya, what to do with this?
My lord, what's my cause of my only grievance is that, my lord, when the matter was referred in the year 2023, it has been, my lord, informed to the petitioner earlier, my lord. By this time, my lord, it would have.
But they have said that the matter is still pending. This affidavit was filed on 6/9/24. What is the stage of the proceedings in that case now? No instruction.
I don't know.
Also heard Mr. P.J. Swekya, learned counsel for the petitioner. Also heard Ms. N. Bodolu, learned standing counsel. No. Who is for respond number 1, 2, or for respond number 3? Miss, heard Miss, huh? Oh, Mr. Your name, madam? P? Heard Mr. P, Miss P. Rabha, learned counsel appearing for Mr. K. Parasar, learned CGC, for the Mr. Correspond number 1. Also heard Mr. R.K. Talukdar, learned counsel appearing for the NHIDCL respondents, NHIDCL, that is the respond number 2, comma, Miss. Also heard Ms. N. Bodoloi, learned standing counsel revenue department appearing for the respond number 3, and Mr. N. Goswami, learned government advocate appearing for the respond number 4, 5, and 6. Also, the grievance raised by the petitioner in the present proceeding is for a direction upon the respondent authorities for releasing only the Zirat compensation, as assessed in the matter on acquisition of the lands land possessed by them. Also, Mr. P.J. Soikia, learned counsel for the petitioner, has submitted that Unaidas was one of the possessors of the land. That the petitioner is the daughter of Tunai Das and sister of Mangala Das. Also, the respondents had issued an allotment certificate in the name of Mangala Das with regard to a plot of land covered by DAG number 233 and 413 in the year 1979, and the same was under the possession of said Mangala Das and his other family members. Also, land covered by DAG number 233 and 4313 was acquired by the respondents for extension of number 37, for conversion of number 37 National Highway into a 4-lane National Highway. Also, in the list prepared of the persons in possession of the land so acquired, the name of late Mangala Das was not included. It is submitted that the petitioner along with others were occupying the plot of land. However, on its acquisition, they had vacated the land in question. Also, the approach made by the petitioner before the concerned authorities for being authorized the due compensation, her due share of compensation, not having revoked any response from the authorities, the present writ petition was filed. Also, the respondent number 5, that is the additional district commissioner competent authority Jorhat, has filed an affidavit in the matter, and therein has taken a categorical stand to the effect that the National Highway authorities had already deposited an amount of rupees 88,84,902 towards rupees as compensation of land, as compensation for the land acquired along with Zirat, so computed against land involved in DAG number 233 and 413. Also, it having been found that there were more than one possessor of the land in question, the amount so received could not be distributed inasmuch as the individual share of each of the claimants could not be ascertained, and accordingly, vide an order dated 30/3/2023, the additional deputy commissioner, competent authority additional deputy commissioner, bracketed LA, Jorhat, had, in exercise of powers conferred under subsection 4 of section 3H of the National Highways Act 1956, referred the dispute to the decision before the principal civil court of original jurisdiction at Jorhat. It is also brought on record that the amount of compensation deposited by the NHAI authorities have also been deposited with the said court to which the dispute has been referred. Full stop. The dispute involved in the matter being referred to the principal civil court of original district jurisdiction. The grievance of the petitioner would now be required to be ascertained in the proceedings so instituted on such a reference being made vide the order dated 33/2023. Full stop. Accordingly, the petitioner herein is required to approach the principal civil court of original jurisdiction to which the dispute involving apportionment of the compensation to various possessors of the land covered by DAG number 233 and 413 of Purani Mati Hotra Koiboto Gaon has now been referred to. Full stop. Anything more required?
Time limit, my lord. Pencil basis, my lord.
We don't know. Full stop. On such a full stop, in the event the petitioner approaches the principal civil court of original jurisdiction to which the dispute has been referred to by the competent authority vide order dated 33/2013 within a period of 15 days from today, along with a certified copy of this order, the claim of the petitioner be also determined by the learned principal civil court at Jorhat in accordance with law. With the above observations and directions, the petition stands disposed. Mr. Das,
Yes, my lord.
there are few matters. We'll just finish it up.
Fine,
We are taking up these two matters for final disposal too.
Fine, my lord. Fine.
We'll just finish up a few matters are there, then come back to you.
Fine. Much obliged.
If you have anything, do it. We'll have it at 2 if required. No problem.
There is monitoring bench matter
Okay.
is fixed on so and so.
We will try to do it.
In the meantime,
Hmm.
much.
Why? Where is the affidavit?
This file has been taken away from over now to Mr.
Does it make any difference? Yes, Mr. KL is appearing. Get it.
May it please your lordship.
Hmm.
The part third matter, if I'm not wrong.
Yes, Mr. Singh.
So this is a part third matter, but still I would like to argue from the beginning. The cause
No,
of
before
action
that,
is
Mr. Soikia,
lordship.
the reason was we were satisfied with the contentions
main
made.
issue.
But the issue was that it was suppressed from this court that a subsequent proceeding initiated was dismissed. This was not brought to the notice of this court,
Lordship.
unfortunately, by the petitioner. I have verified this from the videos also. It's not there. The respondents also did not highlight this issue, although it was a very vital issue and it was not known to them. They had also not brought. Affidavits were
It was known to them or not?
yes, they had also
other side also.
other side also. Thereafter, written arguments were filed. Petitioner suppressed that fact there also. The respondents at one place referred to that with a wrong case number. Why this?
I'm
So
not,
now
I was not there at
No, you were not there. That's why I have
now
I have
we
updated.
have to think it whether it is a bona fide or mala fide. If it is
it-
a mala
it-
fide, lordship will take appropriate action.
No, I'm not on bona fide or mala fide. I don't want to go into
But
that
now
issue.
facts are before this honorable court.
Now the things are before this honorable court.
So
Now,
in
do
that
you have the
situation-
order dated 18/3/2019 with you?
18th. Yes,
Customs
I
Act.
have. that.
Customs Act.
My Lord Justice Bhuya's order.
Yes, sir.
I have gone through this.
After this, is there anything surviving, Mr. Singh?
Yes, it survived.
Okay.
Survived because this was the subsequent stage.
I got it. But
This is a
this court, while passing this order, was apprised of that also. That the pendency of this proceeding was also brought to the notice of the court.
To this court.
Yes.
May
I have called for the records, and there are clear averments to that effect.
This morning I applied my mind, and my opinion is very clear that both the cases should have been heard together.
Naturally.
Both the cases should be.
And what is damaging here, Mr. Soikia, is for you the last paragraph of the order, for the first page, ongoing through.
Ongoing through the materials on record, this court is of the considered view that in the absence of any jurisdictional and legal defect shortcomings in the show cause notice dated so no order is warranted to impede any proceedings pursuant to the said show cause notice dated so.
So,
The opinion, yes, Lordship, I'll address this issue. The opinion of the court, the petitioners are required to participate and cooperate with the proceedings so that the same can be brought to its logical conclusion. Needless to say, if the petitioners are aggrieved of the outcome of the proceedings, it would always be open to the petitioners to avail remedies as provided under the law. So far as the present petition is concerned and the subject matter of challenge, this court is not inclined to entertain the writ petition in the present form. Shortly put, the writ petition is premature at this stage. So above, no consideration of the writ petition is required and the same stands dismissed at the motion stage. Its respondents now shall fix another date for personal hearing and issue notice to the petitioner. Absolutely fine, Lordship, no difficulty. Now, what is the issue? There are two events here. One event is the seizure. That is at the stage 1. Is cause of action regarding the issuance of show cause notice and subsequent proceedings is
this is for confiscation.
Yes, for confiscation. Yes. So that is stage 2. The issue which is raised before this honorable court is relating to stage 1. So Lordship, my humble submission is that whether the subsequent development was brought to the notice or not, that has no relevance. That is my submission.
We want you to take that into account
Yes,
and thereafter
I
make.
will take into account. I'll take that into account. I'm giving an example. I did not find a direct case on this, but I can give an example.
We are open, Mr. Saikia, we are open.
Yes, Lord.
But we want to
Yes,
know
yes.
how this court should proceed in the matter.
Absolutely, I'll try to address.
Where is
that
Mr.
issue.
Cal?
The other side wants to come here, Lordship. I am more than happy because he's always objecting my appearance in cases. So in his absence, I do not want to do cases.
Have you any objection in we continuing to hear Mr. Saikia? Because I don't want to have any other submission made before this court thereafter. Huh? Can hear. Okay.
So I'm giving an example. That FIR has been lost. I file a case to set aside the FIR and the criminal proceedings. The Honorable Court did not pass any order regarding stay. It was pending, going on. In the meantime, charge sheet has been filed. Whether the first case will become infructuous or not?
Will not.
Will not. Same principle will apply here.
Show that.
Very recent case of the Honorable Supreme Court. May I read it, Lordship? Paragraph 4 onwards. The appellant filed a petition before the High Court of Allahabad praying for quashing of the criminal proceedings. The prayer in the writ petition was for quashing of the first information report filed at the instance of the 4 respondents for the offences under so and so. By the impugn order dated 8 May 2024, which is a one-line order, the High Court dismissed the writ petition on the statement of the first informant that a charge sheet has been filed. We are surprised to note that without considering the case of the appellant on merit, the petition has been dismissed as infructuous. We fail to understand how a petition for quashing criminal proceedings become infructuous on the ground of filing of a charge sheet. Only on this ground itself, the impugn order deserves to be set aside. The Learned Counsel representing the state of Uttar Pradesh submits that the High Court does not call for interference as the applicant have an efficacious remedy to challenge the order of framing charge by filing revision application. We are shocked to note that the approach adopted by the state government. What is suggested by the state government is that once charge sheet is filed, accused cannot do anything except to wait till the charge is framed and thereafter can file a revision application to challenge the order of framing charge. At this stage, the Learned Counsel appearing for the state submits that the possibly because of a remedy of filing revision applications against the order framing charge was available, the High Court has dismissed the petition. We do not see any such reasons forthcoming from the impugned order as the petition is dismissed as infructuous without mentioning how it has become infructuous. It is true that the applicant can apply for discharge. However, the scope of application for discharge is completely different from the scope of a petition for quashing of the criminal proceedings. But while arguing a case for discharge, the appellant will not be in a position to rely upon any documents which is not the part of the charge sheet. The ground of abuse of process of law will not be available while arguing discharge application. However, in the petition for quashing either under section 482 of the CRPC or under article.
We have got your point, Mr.
Yes,
Singh.
Lordship. So here the two events are totally separate. Suppose the charge sheet has, the show cause notice has been given, but the very basis is not correct. As Lordship has already said that I am convinced with the opinion that proper reasons to believe was not framed at the time of seizure. So from void ab initio, the whole action was void ab initio, Lordship, that from the very beginning, the foundation was on a very weak footing. It was illegal in my humble submission. So on the basis of a illegal submission proceedings, a show cause has been issued. In the show cause notice, if whatever opinion this honorable gives, I will address to that. I will give the reply to that show cause notice by saying that your foundation has gone by the order to be passed in this honorable court's case. So that will be a futile exercise. I will do that. But I am not running away from the so cause notice also. I will apply. I will appear before the authority, whatever date they gives. But before that, I will have to get an opinion from this honorable court whether that seizure was legally done or not, whether the reasons to believe was properly framed or not. Because they have first seized it, then they have framed the opinion.
Hmm.
It is very clear. On 30th, they have seized the materials in the airport, all gold ornaments.
They had
And on
required your
first-
appearance on first.
first, and thereafter they frame the opinion to seize the goods. So the horse is before the cart. So this is a small issue, Lordship, which is before this order. My humble submission is that although rightly, wrongly, mala fide, non-mala fide, either party have failed in their duties to bring that fact before this honorable court. But that will not change the color of the present proceedings. And till today, I am saying that if the so cause notice is found to be correct, Lordship, and what the honorable court says, it is a premature case. Shortly put the writ petition.
There is a
premature in this
there is a line before that.
I have seen it, Lordship. In the present petition is concerned as subject matter challenge, this court is not engaged. The subject matter is totally, as a result, Lordship, in a so cause notice, I have every right to take all the grounds.
Means the finding of the court to begin with,
Yes.
the first page of the order,
Yes.
last paragraph, is that there is no jurisdictional error.
No
So
jurisdictional.
it takes care of your plea here,
Here,
because that case cannot come into being without this basis.
no, Lordship, from here, what the honorable court says, the perspectives is very clear. Under what situation a so cause notice can be challenged, especially in taxation law?
No, I'll go a step behind that. I'll go a step behind. The court was not concerned here with the challenge. The court was concerned whether that was issued by following the
Due process.
due process.
Absolutely correct.
Why? Why I say if you go through the earlier writ petition, which led to that order, it's challenged basically on this petition itself. You have not gone through the earlier writ petition, I
I
see.
have not gone, it is with me, but I have not gone, I have gone through the order.
You go through the writ petition, the challenge is basically on this.
One more ground could have been taken. But
It was not taken.
That will not dilute the case here.
What I'm trying to say is, this court, on appreciating that this was the issue pending before this court,
No, that was not the the issue before let me just think. I have the writ
writ petition.
petition.
Yes, yes, it's under.
Yes. Here they have challenged the so cause notice.
Hmm.
If they have challenged both, then we have to take a different course of action. Yes. They have challenged.
No,
here
I'm
the so
saying the
cause
ground.
notice.
I'm on the ground of
Page 23. Page 23.
I have
The
said that.
so cause notice has been challenged.
Challenge, as well as adjudication and order.
Yes.
Those are
So that
subsequent-
is the subsequent
No, no.
action has been challenged
No, no,
here.
no, no, Mr. Okay, what I'm trying to put forth to what has come to my notice is,
Yes.
which I want you to deal, is the challenge here basically is also on the reason to believe not being,
Yes, that can be a ground, but that was
and the
not put to
pendency
challenge.
of the present proceeding.
Lordship, my humble submission is, we are very categorical here. The so cause notice dated 16/8/2018 and the adjudication notice dated 26/2/2000 notice and the order dated 27/2/2019 were challenged. So this is a subsequent three actions where this is a different event. This event is challenged here,
Okay.
not the first event. The first event is pending before this honorable court till date. The mistake my colleague advocates have done, that they should have clubbed both the cases. In my humble submission.
Hmm.
Otherwise, suppressing or not suppressing would not make much difference in the adjudication. That is why the other side maybe also have not pointed it out. I do not know, I am not defending anybody. But if the facts are properly placed, then it is effective for the honorable court to take a call.
Hmm.
So my humble submission now is that so cause notice has been issued and the learned single judge, while saying, by going through the materials on record, that first page, last paragraph, this court is of the considered view that in the absence of jurisdictional and legal defect shortcomings in the so cause notice, not in the seizure notice or seizure proceedings.
Hmm.
So seizure proceedings and show cause notice relating to confiscation are two different and separate events. So why this honorable court has said that absence of jurisdictional and legal defects, shortcomings in the show cause notice, because a show cause notice cannot be interfered if the authority has jurisdiction to issue that. Normally, all cases are dismissed at the stage of show cause notice because the honorable court feels that they have the forum before the show cause issuing authority to take up all the grounds. Only when the authority does not have the jurisdiction to issue that show cause notice, then only under 226 the honorable court.
You have the earlier writ petition with you. Come to para 19, page 19.
Yes, Lordship.
Just go through that for you.
Paragraph 19.
Ah.
The petitioner most respectfully begs to.
It's okay, you can read it for yourself. Just
Sure.
have to go through it once.
So there is no suppression.
No, I'm not on that. Not on that.
Yes.
Suppression is not here in the pleadings. It was suppression in the sense that when the matter was being argued, this was not disclosed.
But so now one thing
this-
is very clear.
They
The
have
petitioner
projected.
did not suppress anything.
So the next queries, the court had notice of this
Maybe court also did not go minutely.
because that was the only
Because
ground.
that is why
That
Lordship
is
will
the
see
only ground of
that-
challenge,
no, no,
Mr.
Why
You
Lordship,
cannot
this
presume.
order is very, Lordship will kindly see.
Hmm.
In view of above, no consideration of the writ petition is required. The opinion of the learned single judge. No consideration of the writ petition is required and the same stands dismissed at the motion stage itself. That means no notice was also issued.
Okay. We got your point.
So the honorable court also did not go through the.
We'll
writ
consider
petition.
that, Mr. Sikhe.
So this judgment, Lordship, I am saying, submitting, Lordship, that when a FIR is challenged and the charge sheet is filed, the case will not become infructuous so far as the challenge of the FIR is concerned. If the FIR itself is found to be not tenable in law, then all the subsequent action will have no legs to stand. They will fall flat. So here, if the cause of action for issuance of the show cause notice, we have put to challenge before this honorable court. That means the seizure. If the seizure was correct, then the confiscation proceedings will be correct. If the seizure itself is not correct, not tenable in law, then all the subsequent actions cannot be correct in the eye of law.
Done.
In the reply,
I have a query for you, Mr. Sikhe. There is an FIR which was put to challenge,
Lordship.
but no stay. Naturally, we don't stay
Yes.
normally. So it went up and culminated in a charge sheet.
Lordship.
The charge sheet was also put to challenge. Challenge to the charge sheet negative. What would happen to the FIR?
FIR, if the court finally decided FIR was illegal, it is
No,
not tenable.
what I'm saying is
In
the
that
charge
case-
sheet challenge not negated. Charge sheet challenge not entertained.
Entity.
Not entertained by this court. What would happen to the challenge of to the FIR?
FIR, that issue is still alive. Issue is still alive. Highly obliged, Lordship.
So this is the only thing we have
This is
to,
because
otherwise,
Lordship has already expressed opinion.
yes, where's Mr. Kel? Still on legs, okay. Mr. Sakya, anything more to add to this point?
Because Lordship has put a very
That-
specific query.
That part I have enough materials your colleagues have put on record.
Yes. Now, Lordship, suppose Lordship allows the first part. That means Lordship feels that this is a illegal seizure. In that situation,
Everything will go.
everything will go.
That we have.
Yes, Lordship.
But if I say
Yes.
that my only thing is
If
that
seizure is correct,
no.
if
I-
seizure is correct, then
I'll have-
we'll have to.
before coming to your case, I'll have to examine. That's what I wanted to hear you.
Yes.
What submissions you have made, this decision, whether that subsequent decision would have the effect of ratifying any lacuna that was there in the seizure procedure. So that is the thing which I'll have to examine. If I hold against you, then that's the end of the matter.
Yes, for that, I would like to add one more thing, that
Yes.
the Honorable Court very categorically recorded in the last two lines of the first page. Of
No consideration need to be made.
No, that is not. Just I am repeating to make it more clear.
In view of the
Sir.
above, no consideration of the written
No,
petition is.
I'm coming to the first page.
Okay.
On going through the materials on record, this court is of the considered view that in the absence of jurisdiction and legal defects, shortcomings in so cause notice dated so and so, not with the procedure relating to seizure. So the Honorable Court's opinion is regarding the so cause notice per se. So therefore, the Honorable Court take the view on the basis of the so cause notice, which was considered. And in that situation, the Honorable Court felt that it is premature in nature. You go and approach the authority.
Whatever Mr. Saikia has submitted today,
Yes.
not with the earlier part, that we will,
Yes.
if we
this
come,
point.
we will say that he has made those submissions.
Lordship, this is Lordship's duty to write all these things.
No, I want
Again,
it. I want it to be on record.
No, I'll do that, Lordship.
Mr.
I'll
Kel,
be more than happy to do that.
Mr. Kel,
Tomorrow morning, Lordship will get that.
Mr. Kel, get him. We'll hear him. Mr. Saikia, you need not be here. If something is required,
Lordship,
we'll get
no,
you
no.
back.
I'm just on a lighter vein. I have seen that.
Fair enough.
Highly obliged.
Because I want if I'm going against you, I want to deal with all your submissions. If I'm going with you, it's okay. Fine. Because this was something which was troubling me.
Lordship.
Now you have given a view. Let us examine that.
Lordship. And in writing also, my submission will be
Tomorrow.
highly obliged.
We'll wait for him.
Granted 2 weeks time only, because I have lost my connection with the client. We have sent a letter. The earlier contact number has
Didn't matter.
one
Mr.
time.
P.P. Borwa, Learned Counsel for the petitioner. You are there in the case?
Yes, Lordship, Doctor.
P.P. Doctor, Learned Counsel for the petitioner, submits that as a last chance, he be granted, as a last chance, he be granted 2 weeks further time to complete his instructions in the matter. Full stop. Prayer is not objected to by Mr. B.J. Talukdar, Learned Senior Counsel, appearing for the respondents. Registry to list this matter again after 2 weeks on a date to expire. Yes, Mr. He had asked for compounding. You compound it. Yes, madam.
papers are missing. 2 minutes, Lordship.
Last item is about.
Pending 5.
Five.
Okay.
Four is at 2.
7, Your Lordship. Take a minute.
5 also was there. But Mr. Chaudhary is not here yet. 7. Okay. Hmm. You were supposed to give me some decision. Mr. Saraf has literally made his submission. His case is very limited. That your claim is under the VAT Act 2003. I am trying to get it back myself. 2003. So during that period in his returns, he had shown this amount, but he had not, before 2017, but he had not utilized this amount. So there was no occasion for anyone to question that. Now, when the GST regime came into being, this being available in his returns, he utilized this for input tax credit for meeting his liabilities. So he says that after the repealing of the 2003 Act, the GST having come into being, and this being in satisfaction of a GST demand or a liability, you cannot take any action here. Any action that was there that would have been taken under the GST regime by the competent authorities. Now, in that context, what do you have to say? GST Act. Hmm? What I get? Yes, section. Hmm. You are reading section of the Central Goods and Service. Just a moment, just a moment. More kit, I can't reach. No. No, I've had. Levy on tax on sales. I was just looking at the author of these compilations. A very familiar name. But here, just a moment. When an oil company has been specified in the rule sells any petroleum product other than crude oil mentioned in fourth schedule to another oil company. He is not an oil company. For the purpose of resale by the latter, such inter-se sale between oil companies shall not be deemed to be the first point of sale in the state, but the sale by the purchasing oil company to another person not being an oil, shall not be deemed to be the first point. Huh. So for him, he being not a oil company, that will be deemed to be a sale. Fourth schedule. Let's see the fourth schedule. Schedule to the Act. Schedule 7th, 5th. We have got fourth schedule. Yes. Rate of tax 20%. See, this only says the first point of sale, it would be 20% within the state. Now, your 10B1 explanation says that when the sale within the state itself is between two oil companies, that will not be deemed as the first point of sale. Mr. Sarab, is that the correct interpretation? That if it is between two oil companies, then fourth schedule 20% will not come in. Just for my
Explanation says, if there is a sale between but the sale made by the subsequent oil company
to the person concerned,
to another
third person.
will be treated.
That's it.
Specified companies have been defined, Milord,
Ah.
in the
Hmm.
who will be the specified oil company, Milord? Oil companies are not included here. Proximity School 8. These oil companies specified to the oil company.
No, that's what I'm saying. If the point of sale, the exclusion would come in
But
only.
this explanation had no.
No. Between that, he has said, just for my understanding,
Your auspice, first,
between two oil companies, this question will not come. But that will not prevent you being a purchaser.
I have no difference, Milord.
You have to pay up 20%. And then input tax credit for that.
Actually, because this will be sold by the Assam Gas Company to me. And since I'm not oil company, if I would have an oil company, then Milord, the sale by the oil company, gas company to me will not be the first point sale. It by me will be the first point. Certainly, right? Because the oil company has been defined and nowhere, Milord, it is mentioned here. And if you also see the Assam Gas Company, Milord,
It's there.
is there. So Assam Gas Company, if he is making a sale to assuming to the gas authority,
Then it will be not treated as a sale.
first sale,
Ah.
and it will get second sale, first sale only by
When-
the subsequent oil company to the. Here,
So-
this issue is not there, Milord.
So, Mr. Gogoi, your very basis of his claim for input tax credit to be made erroneously goes.
It is not in the order, Milord. And once something is not in the order, you'll also.
We'll not go into it.
Well, I'm
But
just.
when I'm getting something, let me also pick up.
I'm only submitting, Milord.
Ah.
The order has to be, the validity of the order has to be. Any other grounds or submissions?
Mohinder Singh.
That's the only, Milord.
Yes, Mr. Gogoi, anything more? Your entire contention is because that commodity that he was dealing with, being a commodity under Schedule 4, he is not entitled to any. That cannot be the context, because you have not said that Star Cement is also an oil company covered by your provisions of Rule 8. Huh? Oh, sorry, Udalguri Beverage. Huh? It's an oil company. It's an oil in a different form.
Admitting that input tax credit not disputing
Why he was not legally entitled?
schedule 4 items below bottom. There is no dispute about it, my lord.
Alcohol also not applicable.
That was schedule 4, my lord.
Oh.
The question is not on that, whether he.
But whether you have utilized it for
The question is that on 36 to
act goes.
when he has not utilized that, the authority would have found that he has claimed something on not entitled to, he could have reversed it. Now, that was not done. When the GST came, the person concerned had utilized the input tax credit for payment of the GST. Now, it will be a wrongful availment of the input tax credit under the GST Act. We fall in section 73. Now, once it has been utilized, assuming for the argument's sake, my lord, just for argument's sake, on 36 2017, today, Lordship holds that he can reverse it. What will be the implication, my lord? Because he has already utilized it for payment of GST. His reversal will not do. The GST authority will have to take and initiate actions. And I'm saying that it should be open for the GST authorities to initiate the proceedings in accordance with law.
Okay.
Cannot, I'm saying he cannot.
But Lordship will
Just a moment. Yes, GST 174. 174. Section 174. Awesome. Huh. Hmm. Hmm.
orders or any
Hmm. under the GST Act. Okay. Then why the GST authority sat over the matter? You are also a part of the GST, you are the implementing authority. You could have directed for taking action under that. That would have been the end of the matter. But 14.9a. Just take us through that. 9D. Mr. Saraf has made his arguments on that. Availed means he has utilized that. But he has not utilized it. Under VAT, he never utilized it. He put it there in his papers, but he never utilized that to meet his liability. No. It would have been a situation, he has put it there, you have not reversed. But he has then used that money or that credit to meet his liabilities under the VAT Act. It would have been a different situation altogether. But the VAT Act was allowed to die. Thereafter, he utilized that because it was coming in as undetected. You had it. He had it in his return. You should have taken a call on that when you were processing the matter under 36, 37, whatever it is. Assessments were done, but you did not do anything. He utilized that under the GST regime. Now, GST authorities have not taken any. So, after this reversal, now, once it has been utilized, availed, utilized under the Act, how can you go back and reverse something which what I'm trying to say is 14.9a would come into an operation if it is utilized within the validity of that Act. Now 22, that Act is not there. How can you invoke that Act in 22 for something which was closed in 2017? Already availed or the Act also gone. You have not taken any steps in 2017 for reversal. Now the Act is not there, 14.9d. Now tell me one thing, Mr. Gugoi. Act is gone in 2017. Now, admittedly, there is an error. Something he has done. There is an existence in his returns of this input tax credit. Now, after the Act has been set aside or it has been superseded by the GST Act, whether the authority would have power to invoke provisions of that Act, just for my information, I'm asking you. 174 is in connection with GST. So anything has to be done you have not utilized 174 here. Let's go back to So you're basically on 174(2)(E). Yes. Forty-two is gone, 43 is gone, 43A gone. So not something which has come. Yes, fine. We have got your point, sir. So, Saraf, only one last point that he has said about the repeal.
Assuming
Hmm.
that applying section they have done it. They have done it. They have done it, Milord. Have covered, passed the order for recovery. Admitted that it was not utilized on it. If it was not utilized,
Where is the question of recovery?
question of recovery does not arise. Now, this order now assuming lordship gives them liberty, proceed with the reversal and whatever.
No.
On that, under
5 years. Gone.
Right. Even 8 years for reopening of the assessment. On. Lordship cannot extend the
No,
limitation.
I can't.
Lordship cannot extend the limitation. Friend, whatever is saying that 174 applying, whatever is applying.
Mr. Saraf, subject to correction, I would like to have a comment on you on this as an officer of the court. The 22 notice that they had issued, if they had confined it for reversal only, then it would have been a different issue altogether. They have said reversal and recovery. So by projecting that, you have utilized that for what? The impugn order does not even indicate about reversal. It's only
Recovery.
Am I right in understanding that?
Now I'm coming to another thing, Lord.
Hmm.
You just
Hmm.
tolerate me for five minutes.
No, fine.
The VAT GST Act, Lord, was saying about the rule for
Huh?
authorities. There is no
That
provision
he has in his concluding said that this is not to be done.
saying that the VAT, that the VAT, the input tax was not eligible for it.
Because Mr. Saraf knows that no further proceeding is permissible in the matter.
That is not.
Liberty law.
Yes, yes.
Take a call.
Yes,
One line.
No, liberty. I will not object. I already said, Milord, that the
If I granted liberty, I will have to hedge it with the words subject to the provision of limitation. Well, then why should I give that? You have your
If
power.
you-
If you have your power, you have your power.
If you can show that you have the powers.
You go ahead.
There
I'm
was
not.
section 74 my lord, of the CGST. There is, my lord. Where appears to the proper officer that any tax has not been paid or short paid or erroneously refunded, or where the input tax credit has been wrongly availed or utilized by reason of fraud or willful misstatement or suppression of the facts to evade the. Now, these are the situations. What is the time limit? 5 years. Assuming, for the argument's sake, my lord, the proper officer comes to his notice that somebody has availed and utilized the input tax credit by fraud, by suppression, by misstatement, and with the intent to evade payment of tax after 8 years. Anything? Because the expiry of a period of limitation cannot say that 20 years after it is.
You can wake up any day morning and come up
and
and
say that we have, this is come to a notice and we'll do it.
tax no equity. Now, if the reverse was the situation and the petitioner was in fault and he had to do it, you would have straight away denied, saying that it's not there.
Even
So the
refunds are
same
denied.
principles will apply to you also.
Refunds are denied that it was not, refund application was not filed within 1
Within
year.
the-
It is gone. And here it says that fraud, suppression, misstatement of facts with the intent to evade payment of tax. Somebody has done it. He's a regular my lord evader. His only job is evading the tax. He has done it. Your authority is within 5 years, not after 20 years.
Got it. Anything more, Mr. Gugoi? But Mr. Dr. A.K. Saraf, assisted by Mr. N. Dr. Learned Counsel appearing for the petition, also heard Mr. B. Gugoi, Learned Additional Advocate General appearing for the state respondents. Parties have concluded their arguments. So, registry to list this matter again on 25/9/2025 for delivery of orders. Bill pause.
7 lakhs and something only.
24 lakhs.
An example to open the eyes of the department. Here. Highly obliged. But in one case,
We'll have it on some other day. Any the
on legs.
is on legs.
But my lord, only that day your lordship heard the matter at length, my lord.
Fine, we'll
Your
hear
lordship has
it
not
because
mentioned-
he's come down to that one
Your
point.
lordship has not mentioned the further hearing. At least must mention, otherwise, my lord, all efforts will go.
No. We just had a casual hearing that day, Mr.
But what is casual hearing, my lord? He has admitted everything. Now it is today casual hearing, my lord.
Okay, we'll have it before the vacations once.
So further hearing, your lordship mentioned, my lord. Further
Okay.
hearing has not been part of, my lord.
Some file to him, pass number.
By the admission of 70 lakhs or something, that will have no meaning.
No, ito na, pass number.
What is creating all the problems, my lord? Direction is not for further hearing, my lord. The Supreme Court direction. The hearing the Supreme Court never said.
Dr. A. Saraf, learned counsel for the petitioner, and also Mr. Arcade, Mr. Arcade, Mr. Arcade Dev Chaudhary, learned deputy SGI for the respondents, was stated to be on his legs in connection with another matter, and accordingly, the matter was not taken up for consideration today. The registry to list this matter again on 19/9/2025 as a fixed item. I'm here. Back.
I am obliged, my lord.
My lord, sorry, my lord, here, yesterday night I called the client before I go into the merit of the case. I apprised this honorable court about the development lordship. I called him and I stated that probably it will be like you have to answer in the Kolkata. And he said, whatever the court decides, we don't have. Morning, he told me, you don't appear. Then I said, okay, then let there be a.
Don't appear, I'll dismiss it for default. You don't appear, I'll dismiss it for default.
Lordship, but that
Finished. That's the end of the matter. Nothing, no sympathy here.
another advocate will be engaged, so.
Nobody is engaged, so we are dismissing it for default. Not going on merits, I'll dismiss it for default. You have an interim direction.
Lordship, nothing
Then-
as such. Only question, Lordship, that is the hard dwelling house. I'm also a little.
Madam, the requirement of law has to be followed. No sympathy can be given. Your husband has been convicted for NDPS. So whether the property has been procured from the proceeds of crime, there is a chapter to that for in the NDPS Act, 63, 68 and all.
68H, Lordship.
With that as
That embassy.
Madam, you have been given an opportunity to appear before the authorities, satisfy the authority. This court gave you an opportunity to satisfy this court whether what is the source for buying money for buying that property, right? You have filed an affidavit. Nothing is there.
I told that this money, so far.
Show me, madam, this is a case. Show me from where your mother and your sister has paid. What is their source of income? It's me not saying that you have not showed. You have just made a statement that this money was given by my father, mother, and my sister. From where?
I can show that,
You
Lordship.
need not be. You have been given an opportunity.
And the other part, Lordship, that 68H, if your Lordship that notice the validity of the notice in question because of the fact that 68H has not been followed. There has to be investigation. The investigation.
Make those submissions, madam.
Even
Madam, make those submissions. We will consider if there is any technical error in the notice.
is a technical error.
You argue. You argue. But you have been now asked not to argue.
Morning, I told. Now again, I called him that there is no other advocate I see. So should I appear or it will, because it is also, I also feel, then we go. Then whatever you do like that. He
Then
said.
you argue. We'll be ready.
That is my submission, Lordship, that.
You show me the default here. Fault here. The fault in issuance of the notice. I'm with you.
Lordship, that 68H.
No, come to the facts first. Where is Mr. Parasha? Okay, we'll have it after some time.
Can it be? Lordship, can
Okay, then fine.
taken up in the second half,
No,
Lordship.
no.
I'm not skipping, just second half, Lordship.
No, we have matters fixed at second half today. You make your submissions with first, starting from the facts here. Because we have been accommodating you here
Yes.
as you were praying. Now show me. This starts at page 28, right? Okay, we'll have it at 2. Hey, Mama, election matter to be submitted.
Abla's lodge. Then
तो की बात से नहीं लेफ्ट ओवर क्या था ना ये सब बता रहे से बाकी 18 to KT আছে ও তা কানে রাখি পড়ো কি থাকি গো টাইম নোয়া 4 থাকি কিনে 4 12 8 8 18 yes where is Miss Gay okay yes Mr. Das
Yes, my lord.
I think we'll take up the first matter the initial matter
Well, matter, my lord.
we have already made your submissions
Yes, my lord. In this matter, my lord, hearing concluded. And
so
we
now if we pass an order in that matter whether the second case will take
just explain.
uh,
My lord, in the first matter, hearing was already completed, written submission, everything was done. It was made CAV also.
then I had to
But-
release it
But it came out of CAV because of the IA filed. In
be
the
that as
recent-
it may
Yes, my lord.
now the second case that is there
Yes.
got a connection with the first case
Yes, because of there was an interim order passed in the first case that the daughter will continue her schooling in Milot Sainik school.
any further misconduct committed by the daughter in the second case
No.
it's only a relation with that this case was
Yes, in the first case, issue was compulsory retirement of the father. Now, in the second case, during the pendency of the first case, this incident happened, wherein
second case is
1086. So, in this case, what had happened? A boy came to meet the girl. That
that
daughter.
mobile
Yes, and that has been termed as something, my lord, illegal. And she was without giving any show cause, at least knowing her the reasons or the charges or the allegations, they conducted an inquiry, my lord, and without even furnishing the inquiry report to her to respond, they have passed an order that your lordship will find page 36, transfer certificate.
that is under stay
That is on the stage. She is still continuing.
she is in which class
At that point of class 8, now she is in 9. So a case was investigated by the SCOD in the presence of both the parents, where cadet so and so agreed that she invited cadet so and so to her house on so and so when the parents were not at home. In view of the aforesaid, your ward is suspended from the academic session. However, keeping in the interest of your ward and her academic session, be allowed to appear for the annual exam under your own arrangement. You are hereby directed to collect the transfer certificate of your ward after clearing all dues from the school after exam 24-25.
so your case is that this is nothing but a camouflage so that they have not been able to take action against you in the first
Exactly.
case now they have done this
That is one aspect. Even assuming that the boy had come to my house or the daughter's house, my lord, if your lordships kindly see the manner in which inquiry was done and were arrived, I will kindly have a look firstly page 32 for a moment, my lord. This was first intimation given to us. I am writing to inform you that an indiscipline case was involved your ward Sri so-and-so, cadet so-and-so of class so-and-so has raised regarding her conduct given the serious important to address the situation. Appropriate actions are taken. In view of above, both the parents are requested to meet the school committee so-and-so along with cadet so-and-so by so-and-so. Then, my lord, we ask for video recording of the proceedings. That is page 33.
that was given to you
Oh, no, that was not given to us. What they have communicated, they said
The video recording of the proceedings of your ward cadet so-and-so will be handed over to you just after the completion of all the proceedings and SCOD committee reports, since the committee is um,
Doing the
doing
initial-
the initial investigation, and it's our individual also.
this is
It
a
involves other
communication of
individual also. This was a communication dated 23/1/2025.
Hmm.
In between page 34, you will find. So thereafter, the decision came. The inquiry report of
the same date, sir.
yes, the inquiry report of the SCOD was never given to the petitioner. Not even know what was the outcome, what was collected.
The SOD is the one wherein you had appeared, school discipline committee, and the video recording of which you wanted.
Yes, that is.
Have they filed an affidavit here?
They filed an affidavit.
What
They
is
have,
the stand?
they have filled
47 to 50, they have brought the
SCOD
essay
report.
report.
Yes. Your lordships, kindly consider the SCOD report. Page, it starts from page 66. Page 67 is the findings. After the interaction with cadet so-and-so and so-and-so, the board found that both of them were having a love affair, and they communicate each other via WhatsApp text and call for last 2 months. Finding. Board also found that so-and-so kept unauthorized mobile. That's the boy, my lord. Cadet so-and-so kept unauthorized mobile, which was not known to the housemaster. This is not connected to me, my lord. That is connected to the boy. The board also found that the statements of both the cadets and WhatsApp on so-and-so, cadet Harshita Deka invited cadet so-and-so to her quarter as her parents were quarter. By knowing the school rule, the staff quarters are out of bound of cadet seal so-and-so, visited the quarter and spent approximately leaving the house, and they have shaken hands and hugged each other. The finding. Their main finding is that there was some.
What happened to that boy?
Boy, my lord, he was to withdraw him from school was also taken, but he continued in the school. No,
He's continuing in the school.
he continued because I have got, my lord. I'll just take a printout and give class 8 the merit list, which was probably result sheet. His name was there.
It can be because they both were
Yes.
in the same class and they were permitted to continue.
But he was not withdrawn from the school. What happened is that, my lord, for getting admission in class 9, they are to secure some cutoff mark. He failed to secure that cutoff mark. That instruction I have taken. He failed to secure that cutoff mark. That's why he was not given admission in class 9. But no disciplinary action by virtue of withdrawal.
So any person in the school not getting the cutoff marks
Yes.
will not be permitted to take.
Except, yes.
So your client, the daughter,
Secured.
she secured, so she got admission in class 9. She's in class 9.
Yes. So recommendations, keeping in the seriousness and sensitivity of the incident to prevent such occurrence in future, the larger interest of the school, it is recommended that both the cadets, namely so-and-so, be withdrawn from the school as per rule 3.32 of Sainik School Society's
So
rule.
this is the only thing. The
Lab
summary
affair?
proceeding that has been done,
Yes.
the summary proceeding was done keeping you in dark of the materials available with them. The report of the SCOCD was not given to you, but the recommendations therein were sought to be implemented, for which you came before the school.
Yes, madam.
So your case is that even if it is seen with regard to the allegations at large in a broader perspective, the same would not mandate such severe action on your
Exactly.
ward.
Exactly.
And they should permit her with some warnings, whatever they want, they'll do it.
In fact, this type, if first of all, it was, they say that it was a love affair. My lord, platonic thing, my lord, in that teenage, it happens. Even if you have find something, my lord, which is not wanted inside the school, my lord, you've done some counseling, my lord. There's class 8, my lord, it's a it's an age, my lord, wherein, my lord, things are to be taken care of with high sense of sensitivity.
Anything more?
My lord, one aspect, my lord, they relied on one school diary, lord, wherein there were some instructions to the cadet. They say, as per these instructions, he has been withdrawn.
And
from
what
the
are these WhatsApp messages?
that I, my lord, I very difficult to
Who has brought this
consume
on record?
the school. How can a WhatsApp message of a juvenile can be retrieved in this manner and made public? That Lord, I have taken this plea in my affidavit in reply. Lord, under what provision of law you have made this public? And they're so confidential messages, my lord. I find it difficult to read. This part of the sense prevail at all, my lord.
Who has filed this affidavit?
This affidavit was filed by
Principal.
Y.S. Parmar, the principal, my lord, who had dismissed the upon the father also.
He's a colonel.
He's a colonel, my lord.
He's continuing as the principal of that school.
Perhaps he has been transferred now, no? He has been transferred out from here. Whoever is there, my lord, but the thing is that this of actions appreciated. My lord, what I wanted to project before your lordships is that page 107 of the affidavit. Herein, my lord, they say there are situations wherein withdrawal be done. This act, which has been alleged, was not part of all these.
Where is that? 107.
Page 107 of the affidavit, my lord. Following acts on the part of the student may result in their withdrawal from the school without any previous warning. Stealing, cheating, impersonation, ill treatment, or of other cadets, ragging in any form, and manhandling, malpractices, or use of foul means during exam, incident act, indecent act, misbehavior with any of the staff members, failure in exam. Your decision doesn't.
This WhatsApp message is from the boy or from the girl?
They have retrieved from the boy's mobile. If I take your lordships to one statement of the boy, in fact, they are saying I invited the boy, but boy in his statement had page 74, your lordship will kindly come.
72.
74. It's a handwritten statement of the boy. I'll just take your lordships down below, fifth line from down below, my lord. The line starts with I ask her that could I come over? Said not to take risks, but still wanted to see her as I really missed her. So the allegation that the petitioner girl called the boy, it's absolutely.
But the parties at length. Our hearing remains inconclusive. Registered to list this matter again on Friday at 2 p.m.
Much.
Let me just go through it.
Fine,
And both of you, as officers of court, show me, just explore. I'll also want to explore. To what extent, in such circumstances, the privacy of the student is to be protected? May go against you,
Yes.
may go, but
Yes,
we want to learn,
definitely.
we want to understand. In such circumstances, how far the authorities can, in the name of maintaining discipline, also injure the future of the child, even if it's a girl child, or invade into their privacy, and if permissible, to what extent?
Allahabad High Court judgment.
What is?
Single judge. Look, it's a judgment just, my lord, so nicely described.
No, these are in the context of university students.
Sensitivity in
That's what is troubling me.
that has been dealt with here, para 93, 98, 99, 144, 15, 47, 148. I'll mark the paragraphs, my lord.
Just mark it here. Just want to know the power of judicial review. I'll go through it, but extend the privacy of these kids would be required to be violated to understand the extent of the indiscipline committed by them. Indiscipline, you go do.
Like their statements, look, there's small
Minus,
facts.
what is the value of their statement?
Their statements have already been taken. Thereafter, where is the requirement of WhatsApp chat and yes,
It would yes.
question it.
Friday, 2 p.m. Class, huh? Class যদি করে বলাঙ্গা। কোন আছে? Gogoi. Mr. Gogoi, you are there for item number 15.
Much obliged.
Yes. Go আছে লিঙ্গে ঠিক মাটাতে।
Relates to compounding.
Madam, the stand in the affidavit is that this compounding was required by you only.
What is their stand? Because unless and until I myself say compounding can and anyhow cannot be done. That is the
Okay.
first requirement.
So you have asked for this compounding and they have done it.
Lordship, even though Lordship, maybe I will be able to tell that or not, but we are disputing that we have told because even
How
though
can you?
no Lordship, that is what I'm coming. I am disputing because the letter, even though given by because the Guwahati persons they have paid the money, but the compounding letter they have taken from somebody from Shillong. That was not an authorized person. That is what we are saying. But at this stage, Lordship, because it's a Article 226 petition, we cannot dispute that. We will go straight away to the Lordship, the main issue which we are purporting that compounding has to be done by the has been defined under the Act. Even if I say, I don't say, that is not the issue. Lordship, the main thing is that compounding of offense can only be done by a commissioner. In this case, Lordship, the compounding has been done by superintendent, Lordship of taxes. He could not have compounded the offences when the Lordship section 89 specifically provides that it is only a commissioner. Lordship, if you section 89 of the act, it specifically says the commissioner. Now, Lordship, the superintendent can also do only in case the commissioner can delegates his power. In this case, Lordship, under the VAT Act, no notification has been issued wherein
Yes, Mr. Gogoi, what is that?
they're silent in this affidavit, Lordship.
Okay, got it. Okay, what is that you want to refer to, Miss?
Lordship, section 89.
I got it. What do you want to say?
Yes, Lordship. That even if Lordship I say or not say, but the officer can compound the offense. Lordship, if today, Lordship, I go before an officer who doesn't have the power to do that, only because, Lordship, I say or not say, he cannot issue that order. The order can only be issued by the officer which has been prescribed under the act that he can issue. And he has not delegated on this issue, Lordship, their affidavit silent. Section 89 of the Lordship VAT Act. Lordship, compounding of offense. The commissioner may either before or after institution of proceedings of prosecution for any offense punishable under section 5 or under any rules made under this act, except from any person charged with such offense by way of composition, where the offense consists of failure to pay or evasion of any tax recoverable in the provisions of this. In addition to the tax or recoverable, a sum of money not exceeding double the amount of tax recoverable, provided that the commissioner shall not accept any sum by way of composition which is less than 25% of the amount of tax recoverable. In any other case, a sum of money not exceeding 50,000 subject to a minimum of rupees 2,000 in addition to the tax recoverable. Commissioner says not confound an offence under this section and pass an order for payment of composition money unless the person concerned admits in writing that he has committed the offence. And where the commissioner compounds an offence under this section, the order shall be in writing, specify the offence committed, sum of money paid, due date for payment, and date by which the proof of such payment is to be produced, shall be served on the person who committed the offence and shall be final and not subject to any appeal. On payment of the full composition money, no further proceedings shall be taken, and in the offence and the
Avelia,
yes.
the demand was for
Lordship, the case, what exactly the case was? There was no demand against me, Lordship.
okay.
No
That
demand.
offense was that you had used a forged.
Lordship, I am a
Document?
transporter.
You are a transporter. You have put that blame on your driver.
That's all. My driver. And
Driver.
also put the blame on my driver. only.
Whereas Bharati Airtel, for whom you were making this transportation,
Transportation.
they have written that, see, these documents are not ours. This is manufactured by you. So in that view of the matter,
Manufacturing.
I accept your proposition that under 89, the authority other than the commissioner should not have done this. Now, you had approached it as Telecom Logistic Private Limited. So while compounding the thing, an amount was worked out. Now, the amount was paid. Why? Why the payment was made? If the
Yes,
procedure
yes, Your
is
Lordship. Yes, Your Lordship. Now, Lordship, what has happened that I have a duty to Lordship transport the goods. These goods did not belong to a state of Assam. There was no transaction to be done in the state of Assam. The goods were coming from Meghalaya going to Andhra Pradesh. And it was only the Assam was only in the route, en route. And Lordship, that position, Lordship, earlier.
that is gone.
Uh,
You had used forged documents, that is there.
Lordship, not forced documents. No, not that. Not
That is admitted.
Lordship.
The forgery of documents are done by driver in collusion with someone else. That is your stand in the reply.
No, Lordship.
Yes,
Lordship.
come to page 128.
Lordship, the factual situation, Lordship, what I would like to state is that when the goods.
Who is this Ashish Mathur?
Lordship, 129 is the affidavit.
128, huh? Affidavit. Who is this Ashish Mathur?
Affidavit Lordship, what is the internal pagination, Lordship? I think
Internal page is 14.
It is there.
Your communication dated 29/12/2012.
This is the order by the Supreme
No,
Court.
29/12/2012. One Ashish Mathur. Is it there in the writ petition, Mr. Gogoi? No. Okay.
We have made a specific, Lordship, this.
No, I got it. Now, if you come to the impugned order,
In order, Lordship, which is at page 87, starts from page 87. Lordship, Lordship, the relevant portion is page 90, Lordship. Lordship, the third paragraph. I'll read for third.
I got it.
Then I will.
I've seen it. Now we come to page 91.
Yeah.
So this letter, the transporter has submitted petition placed at serial number 73, in which they admitted that the false documents were produced and other negotiation and after negotiation offered that the offence be compounded against composition money of 899.016 being equal to the tax. So and so compensation fixing 91 placed at serial number. Ashish Mathur, the Vice President, has appeared and submitted a petition along with a draft of rupees so and so drawn on Axis Bank towards. Now this letter which you have written, your company has written, is at page 128, running page. Who is this Arun Mathur?
Lordship, we have no knowledge because we have not authorized him. He is some employee, even though he is some employee, not in, because Aum Telecom Logistic Lordship is all over India.
Too difficult to accept that
Yeah.
proposition, madam.
Someone from Meghalaya Lordship, and we
Ashish Mathur, Vice President.
he reflects himself as vice.
Where have you said that he is not your employee in your
Lordship,
petition?
I have revealed, Lordship,
Where?
that he has not been neither the this authorization was given to them now, nor he was Lordship power of attorney holder to submit on behalf of the company. And
Where?
done by yeah, here. Mr. Ashish Mathur is
Madam, I'm sorry, that is not your stand. You have rather accepted the position, but you have
But
taken.
now I cannot say that, even though I have made a statement as such, but at
No,
this
you have not made a statement.
because this
That
is
Arun Mathur was not an authorized person. You have not made
Ashish
Ashish Mathur was not an authorized person. You have never made a statement to that effect.
I
Rather, in the your legal head's letter, it's rather the contrary portion.
but if the letter has been written by some burning heart.
It was a case wherein Mr. Gogoi should have proceeded against that superintendent if he had acted beyond his jurisdiction, because around 25, 27 lakhs penalty was also required to be.
No, Your Lordship, I'll
If the proceeding comes, a demand of penalty would have been there, which has totally been done.
Lordship, only penalty demand can be levied on us. Because why, Lordship? Because tax cannot be levied on me. I being a transporter. Lordship, who am I, Lordship? That has to be seen by this honorable court. I am just a transporter transporting goods from this place to
But
that
you
place.
were the person who was.
I'm just a transporter, Lordship. And the goods belong to, Lordship, the person from Meghalaya.
Bharatiya Airtel has come up, said that we were moving this material from Meghalaya to Andhra.
Andhra Pradesh.
And
we
don't know. We had given complete documents why he is doing this.
If somebody has given me complete documents, the documents are there. Lordship, the drivers, Lordship, they have accepted the fact that the drivers are illiterate. They don't know which paper, the papers were there in the trucks. Now some other, Lordship, the consignment keeps on moving. So other papers were also there in the truck.
We'll consider.
They said that it is forced. Lordship, my main submission is that, Lordship, if only the commissioner has the power to, even if I go and say, that is what I am submitting.
We'll also note that where have you said in which paragraph that he was unauthorized, he was not authorized?
Lordship, I have said in the actually Raman Jha, I have written page 22.
What have you written there?
Last paragraph, Lordship, last 7-8 lines, Lordship. A copy of the said letter was it was very surprising to note the said letter purported to have been issued by the petition was never issued by anyone authorized by the petitioner. And the same was also contained the seal of Baniyat instead of Assam, and also purported to have been signed by one Sri Jamanja without any power of attorney issued in any such name by
That is not the letter.
Same must be taken under counsel.
There is another letter by your vice president, which you have not dealt with. And you have not even brought it on record.
Lordship, because Lordship, the copy cannot be with me, Lordship, firstly. And the secondly, Lordship.
And madam, they had filed an affidavit. That affidavit had contained a note. You deliberately did not want to your petitioner did not, you did not file a reply. So your opportunity was there for you. That's the end of the matter. We'll see. We'll consider your case also. Heard the parties at length. Registrate to list this matter again on পোন্ধৰ আগত নহ'ব না। পোন্ধৰ আগত নহ'ব। On 14/10/2025 for delivery of orders.
Lordship, for further hearing, Lordship, I will just place only on this letter. Only on this letter, Lordship.
No.
Other, Lordship, I'll place, Lordship.
You have done with it. Now I cannot permit you, madam.
Some, Lordship, this one.
Appellate. If I go against you, appeal. I may come against with you also, but I don't know. But I have got the things. I have made my mind clear to you. So
Lordship, only thing is that, like, if since it is on record, if I want to, Lordship, dispute it, I have to go. There is a judgment of this of another honorable court that this cannot be brought into Article 226. We can do it before the lower court only. But only thing, Lordship, my legal position, which I want to make it clear, is that, Lordship, the commissioner, if I go before the law officer.
That we will consider whether there is a delegation, because the superintendent's power says that in exercise of the powers conferred under 89 and delegated to me.
Not delegated, Lordship. They can produce the notification. They have
That you have
accepted the
not
affidavit.
disputed, madam.
Lordship, I have disputed that.
Where? No.
Lordship, in my entire case is only this.
You have,
He has not been delegated and they have not
but
accepted.
they have said that it
They've
was
accepted
there
the affidavit.
on the face of the order. We'll
No.
see. We'll see.
That is my only case, Lordship. That is the only case which I
If you
filled up.
find something, but no pleadings will be permitted.
No, Lordship, I will not.
But if you have any judgments to support your
I'll be
case, you can always give it to her before that day. Thank you. You have the instructions? The case is still pending. Okay, fine. Yes, madam. Show me to Diashi, NDPS Act. Narcotics.
Up page 28, our application.
Yes, madam.
I take your sentence.
Hmm.
Whereas I, so and so being the competent authority in section 68 of the chapter 5A of the narcotic of relevant information and relevant materials available to me, reason to believe that the property is described in the schedule and hereto which are held by you or on behalf are illegally acquired property within the meaning of clause G of 68B of the said Act. Holding such property is prohibited as per 6 IDBC. So first, Lordship, he has to gather an information under 68D, Lordship. 68D, that he has every reason. Before that, Lordship may please to see the property details. Property details are
Page 29.
yes, page 29. And here, Lordship, basic challenge in this petition is the only dwelling house that is the landed property of Runudas, because Runudas is before your Lordships, not Deepak Das, Lordship.
Now
And
come to page 31. That is the reason to believe.
Page 31. Consequent upon seizure of 1.so cannabis, Deepak Das, so Janapur.
Come to the third paragraph.
The intelligence officer NCP who had traced identified properties acquired by AP and his relatives within the ambit of section 6E of the Act had possessed these freezing related to the so these are the property described, and last description is the house, dwelling house of the present petitioner, that is 3 lakhs rupees. So this is
Therefore, the reason to believe is also given to you.
This is not Lordship, subject to my correction. This is not up to the mark. They have to avail from the local police station. There has to be an inquiry regarding whether this property has.
Show me the provision. That's all. We'll interfere with it if required. But show me the provision.
Section 68E. identification. That identification is very important. I'm sorry, Lordship, I have to take up this from my mobile.
Second book असे नहीं है मटर.
8.
We can start from 68A itself. Forfeiture of illegal acquired property.
Lordship, 68E straightway identifying illegally acquired property. Every officer empowered under Section 53 and every officer in charge of a police station shall or receipt of information is satisfied that any person to whom this chapter applies hold any illegally acquired property, he may, after recording reasons for doing so, proceed to take all steps necessary for tracing and identifying such property. The steps referred in subsection may include inquiry, investigation, or survey in respect of any person, place, property, assets, documents, books of accounts in any bank, public financial institution, or any other relevant document. Any inquiry, investigation, or survey referred in so and so shall be carried out by an officer mentioned in subsection in accordance with such direction, guidelines, or competent authority may make in this behalf. So this is a mandatory compliance. This has not.
So what
been
is your
completed.
what is your stake
This
here?
commission, before they hold this presumption that this property has been illegally, they had to carry the preliminary. They had to carry out a inquiry. The reasons has to be satisfied that yes, that this identification, this investigation has gone through, and this is the outcome of the investigation. And in fact, after investigation, it can be concluded that this property has been illegally acquired, and this is the absolute source of this contraband traffic income. That is. So
Your case is that the police has not done this investigation, so 68E is not satisfied.
not satisfied.
But ma'am, the provision itself provides for even an officer competent under the empowered under section 53.
Identification lodge.
Identification
mandate
section
law.
53 says
They themselves only because these are the properties, only because petitioner's husband was convicted in a case.
that's
that
right.
presumption
They have drawn a presumption on the basis of the investigation made that this land which was acquired, maybe acquired in your name, was acquired proximate to that period when he was stated to be involved in that illegal business. So they came to a conclusion. They have issued a reason to believe order. And thereafter, they have given a notice. And the notice is not required to be given to you. It is to be given to the accused. A copy to be given to you. So they have then notice 68H. First, there is a freezing of the property, which is already done. Then 68H.
in 30 days. I am basically on that point, that violation of that lordship, that investigation has not been carried out so as to ascertain the fact that whether this
The only thing you got to do now is to satisfy the authorities that this property is not brought from the proceeds of crime. There is a definite source from where you have acquired the money to buy this. That is from your mother and your sister. They will have to go up and say that, see, this is our income source. From this, we have brought for my daughter and sister this property. That's the end of the matter. And the proceeding is still pending. Because of this proceeding. See? You have an opportunity now.
Is my all documents.
You can place your documents. You can, I gave you, that's why my intention was to give you a chance to bring on record, but you have failed. Only a statement, but that will not do. Statement will not do. You will have to show that this was the amount given by my parents or sister, whatever it is. Because in your writ petition, there is no disclosure. It's only when I asked you, you filed an additional affidavit. And therein also, I was expecting Ms. Som to bring on record something which will prove. They'll have to show their income tax returns. From the income tax file, they'll have to show that this is the surplus we have in our hand. This is my job. This is my thing. I brought this property. There is no stay order also.
Order. This is the only question, that is the only dwelling house of the petition
That is fine, madam. It
along
may
with
be.
daughters.
But there is a provision of law that if it is brought by the proceeds of crime, then on conviction of that person, it has to be forfeited to the government. Now they have followed that. Now the hearing is pending. Confirmation hearing is pending. So you approach.
The identification and that this part are not there from them also, Lord.
They only have to have a doubt. That's all. You have not gone up to them and said that, no, this property brought in my name is brought by money given by my parents or my sister. You have not said that.
When I was interacting with that, yes, there is a document from sister and mother regarding handing over the money that was there.
Now, today that would be doubtful because is
That
it a
is the
registered
thing.
document? It's a registered document. Is it a registered document? Then, madam, then. It may be a proper document, but again, that will be shrouded in mystery. Anything more, Mr. I'm only relegating you to the authority who has issued this notice dated 14/10/2022 and requiring them to give you an opportunity and thereafter proceed with the matter in accordance with law. That much only. Right? Heard Ms. T. So, learned counsel for the petitioner. Also heard Ms. A. Gain, learned CGC, appearing for the state respondents. The petitioner in the present proceedings has presented, petitioner by way of instituting the present proceedings, has presented a challenge to a notice dated 30/12/2015 issued by the competent authority and administrator, Kolkata. Under Narcotics, Drugs and Psychotropic Substances Act, 1985, requiring her to show cause under subsection bracketed 1 of section 68H of the Act of the Narcotic Drug and Psychotropic Substances Act 1985, hereinafter referred to as the Act of 1985, as to why the properties as mentioned in the schedule of properties is not to be declared to have been illegally acquired properties and forfeited to the central government under the provisions of the said Act of 1985. Also, the petitioner having not responded to the said notice dated 30/12/2015, a hearing was fixed in the matter and the petitioner was wide notice dated 14/17.10/2022 required to appear before the competent authority and administrator at Kolkata for finalizing the presumption drawn with the properties as mentioned in the schedule to the notice and to the communication dated 30/12/2015. Also, as projected in the present writ petition, the petitioner herein, when did you marry her? Marry?
40 years.
Hmm?
Yes.
That you have not disclosed. Petitioner is the wife of one Deepak Das. Also, said Deepak Das was found to be involved in, was found to be dealing with narcotic substances, and accordingly, on 5/1/2013, while a consignment of ganja was being transported in 2 vehicles, a search and seizure being held, the said contraband material was found to be recovered from the possession of the petitioner, of the husband of the petitioner, Deepak Das. Full stop. Accordingly, a case was registered in the matter, and the learned special judge took cognizance thereof, recorded evidence, and eventually charges came to be framed against said Deepak Das and others found to be involved in the matter. Also, on conclusion of the trial, the learned trial court in NDPS case number 24/2013 convicted the husband of the petitioner, that is Deepak Das, under section 20 bracketed B bracketed small b bracketed C, section 8 bracketed C, and section 29 of the NDPS Act, read with section 149 of the IPC, and sentence him to undergo imprisonment for 14 years and imposed fine of rupees 1,00,000 hyphen. So, in default of deposit of the fine, the husband of the petitioner was directed to undergo further imprisonment for 6 bracketed SIX bracket over months. Also, the husband of the petitioner was further sentenced to undergo rigorous imprisonment for 14 years and a fine of rupees 1 lakh with default stipulation under section 29 of the NDPS Act. So, the sentences so imposed were directed to run concurrently. Also, being aggrieved by his conviction by the trial court, the husband of the petitioner assailed the same before this court by way of instituting a criminal appeal, being CRL.A bracketed J bracket over 5 of 2015. The said criminal appeal was taken up for consideration by this court, and wide judgment and order dated 27/2/2020, the same came to be dismissed, upholding the conviction of the husband of the petitioner by the conviction of the husband by the trial court. Also, pursuant to the conviction of the husband of the petitioner, of the petitioner, the competent authority, after recording a reason to believe, after identifying the properties involved and recording a reason to believe that the same were so obtained from proceeds of crime, recorded his reasons to believe in the matter. Also, the said reasons to believe recorded on 30/12/2015 was forwarded to the husband of the petitioner, while a notice issued under section 68 H down bracketed 1 bracket over of the Act of 1985 on 30/12/2015. So, a copy of the said notice, along with the reason to, along with its enclosure, that is the reason to believe recorded by the competent authority, was also forwarded to the petitioner hearing. Also, in the schedule of property more particularly with regard to the immovable property which has been held to have been acquired by the husband of the petition from the proceeds of crime of the received by the husband of the petitioner is a property is a land measuring 2 kathas obtained in the name of the petitioner herein on 23/6/2008. Also, the petitioner being aggrieved by the said notice dated 30/12/2050 and the further notice dated 14/17.10/2022 requiring her to appear before the competent authority, for further proceedings in the matter, had approached this court. Also, Ms. T. Soames, learned counsel for the petition, after reiterating the above noted fact, has referred to a deed of sale dated 19/11/2011 and has contended that the said property was brought by the petitioner in her own name. Also, on a query being made by this court as to the source of income of the petitioner from which she had brought the said property, Ms. Soam had filed an additional affidavit on 4/8/2025 and had therein contended that the said property was brought by her on assistance from her mother and her sister. It was contended that the amount requisite for the payment of the amount to the vendor of the property, including the registration charges, were borne by the mother and sister of the petitioner. Accordingly, Ms. Soam submits that the respondent authorities could not have drawn adverse presumption with regard to the said immovable property existing in the name of the petitioner herein. Also, in the above premises, Ms. Soam submits that the respondent authorities, having not carried out a due investigation in the matter, and only on the basis of a suspicion having also incorporated the landed property existing in the name of the petitioner to also have been illegally acquired property from the proceeds of crime received by her husband, the impugned notices dated 30/12/2015 and 14/17.10/2022 would mandate an interference by this court. Per contra, Miss, I'll put it in your name or in your name, Miss A. Gain, learned CGC. Put Mr. Parasa's name also. Okay, Mr. K. Parasa, learned CGC, and Miss A. Gain, learned CGC, have contended that the respondent authorities had strictly complied with the provisions of Chapter 5A pertaining to forfeiture or illegally acquired property, and had, after recording its reason to believe, proceeded to issue the notice dated 30/12/2015 to the husband of the petitioner as well as the petitioner herein. The petitioner had not responded to the said notice. Also, it is further contended that the petitioner was duly informed of the date of hearing fixed in the matter wide issuance of the notice dated 14/17.10/2022. However, she had not also responded to the same and had instituted the present proceedings. It is submitted by Ms. A. Gain, learned counsel for the petitioner, that it is open to the petitioner to bring on record before the competent authority and administrator NDPS Act 1985 materials to justify that the immovable property as identified in the notice dated 30/12/2015 was not so acquired, basing on the proceeds of crime that may have been received by the husband of the petitioner. However, the petitioner failed to discharge her burden in this connection. Also, Ms. Gayan, on instructions, has submitted that although the hearing in the matter was fixed on 16/12/2022, wide notice dated 14/17.10/2022, the said matter has not been proceeded with on account of pendency of the present proceedings. I've heard the learned counsel for the parties and also perused the materials available on record. It is an admitted position that the husband of the petitioner was on 5/1/2013 detained in connection with dealing with contraband articles, and a case in this connection was registered against him. Full stop. The said case, the cognizance of the said case was taken by the learned special judge Kamrup /M, bracketed M, in NDPS case number 24/2013. Full stop. The charges being filed, being framed, and the petitioner and other accused having claimed, contended to be not guilty, a trial was held in the matter. On conclusion of the trial, the trial court proceeded to convict the petitioner's husband, Deepak Das, in the matter, and had sentenced him to imprisonment as noticed herein above. The appeal filed by the husband of the petitioner before this court before a criminal appeal filed by the being aggrieved with his conviction, the husband of the petitioner had instituted a criminal appeal before this court, being criminal appeal bracketed J number 5/2015. For this court, a division bench of this court, on a detailed consideration of the issues arising in the matter, was pleased by judgment and order dated 27/2/2020 to dismiss the said criminal appeal, upholding the conviction of the petitioner by the trial court, husband of the petitioner by the trial court. Also, it is seen that after conviction of the petitioner and the dismissal by the trial court and the dismissal of the criminal appeal by this court, said criminal appeal by this court, the competent officer had traced and identified certain movable and immovable properties which was suspected to have been so acquired through the proceeds of crime received by the husband of the petitioner. Amongst the property the property so identified to have been acquired from the proceeds of crime also includes a parcel of land measuring 2 katas and a house standing thereon, which was so acquired in the name of the petitioner herein. Also, the petitioner contends, the petitioner the pleadings of the petitioner brought on record in the present proceeding reveals that a contention has been raised that the said property was not acquired from the amount given to her by her husband, but was so acquired basing on the assistance extended in the matter by her mother and her sister. Also, it is further submitted that the mother and the sister of the petitioner had borne the cost of the land as well as the registration charges. While the said statement has been made, no material has been brought on record to highlight the source of income of the mother as well as the sister of the petitioner, basing on which the said payment for acquiring the land in question was extended to the petitioner herein. Accordingly, this court is not in a position to arrive at a conclusion that the property in question existing in the name of the petitioner was so acquired, basing on the assistance extended to her by her mother and the sister, and also that the mother and the sister had adequate income for the purpose. Also, as noticed herein above, this court, on a perusal of the materials brought on record, does not find any inconsistency either in the reasons to believe recorded by the competent authority as well as the notice dated 30/12/2015 issued to the husband of the petitioner and the petitioner herein. Also, the said proceeding having not been concluded and having been brought to the notice of this court by Ms. Aga and learned CGC, that the said proceedings have been kept in abeyance in view of the pendency of the present writ petition before this court, this court is of the considered view that the petitioner would have an opportunity to place her stand in the matter before the competent authority, and accordingly, in the event the said proceeding is directed to be taken to its logical conclusion, no prejudice would be caused to the petitioner herein. Also, in view of the above conclusions drawn by this court, and this court having also held that there was no inconsistency in the initiation of the proceedings in the matter against the husband of the petitioner and the petitioner herein, this court requires the petitioner herein to approach the competent authority and administrator, NDPS Act 1985, Kolkata, who had issued the notice dated 14/17.10.2022 and to file appropriate application before the said authority within a period of 2 months from today, and therein bring on record all requisite materials to dispel the presumption drawn in the matter that the property, immovable property, as incorporated in the schedule of property to the notice dated 30/12/2015 was so brought out of the proceeds of crime received by the husband of the petitioner. Also, the petitioner shall, in her said application, also bring on record materials which would establish that the said property was so acquired by her out of assistance given by her mother and her sister. So, on such application being filed, along with a certified copy of this order, the competent authority shall proceed to grant an opportunity of hearing to the petitioner herein, and thereafter on verifying the contentions raised by the petitioner, proceed to take the pending proceedings to its logical conclusion. Also, it is also provided that prior to passing of appropriate orders on conclusion of the hearing, purported orders after giving due opportunity to the petitioner herein, the property in question be not encumbered with, with the above observations and directions, the present writ petition stands disposed of. At line likha thate aru. In the event the petitioner, in terms of the liberty granted herein above, does not furnish, submit the application along with requisite materials within a period of 15 days from today, or within a period of 2 months from today, the competent authority shall be at liberty to proceed with the matter ex parte and take the same to its logical conclusion in terms of the provisions of the Narcotic Drugs and Psychotropic Substances Act, 1985. Tarpishot with the above observations and direct.
I'm highly grateful. Lordship.
Ma'am, we can't do nothing here. That's why. I gave you an opportunity, you could not take it. Okay. Yes, Mr. Bora. We can't help it because the no, there is an allegation, Mr. Bora, that you had deducted the amount and you had kept it for around 2 years. No. Deposit is after 3 years, 2 years. That who will answer to that? Because he has been made to suffer because of your action. No, but you have not paid the amount. We have asked you to pay the amount. No, you deposit this amount. Mr. S. Bora, Learned Standing Counsel, GMDA, submits that the cost as imposed by this court-wide order dated 14/8/2025 for the default in not filing the affidavit on behalf of the respondents represented by him, shall be deposited on Four 9/2025. Registry to list this matter again on 8/9/2025. Registry to along with a report with regard to the deposit of the amount in question.
That nine on the hearing day, my lord.
No, we are only for that deposit. Then we'll give him some time.
Fine.
We'll have to give him some time. No. Mr. Cal is all we know your thing. Why should you seek an apology? We are here. Now tell me, why this first writ petition disposal, second writ petition first disposal was not brought to the notice of this court? If you say that that is of inconsequential, I'll close the writ petition. You were there. 19. No, you could have told me that during the hearing. And you you have submitted a written argument, and therein you have given a wrong number. We had heard Mr. D. Soikia after we had conferred with your junior as to whether he has any objection in the matter. He had said that he has no objection. No. Because you were not here. It's a very sensitive matter. So we had asked whether he can continue with it. Then he has said that he can continue, and I think he has made his notes. Okay, thank you. Now proceed. What is your stand?
After completion of inquiry, notice petty loss.
No, no, I've seen it. I've seen it. They have not appeared on the dates so fixed. Now, Mr. Saikia has raised a argument by drawing a simile from a challenge made to a FIR. Subsequently, stay was not there. The police investigated and a charge sheet was filed. He said that filing of the charge sheet would not would not render the challenge to the FIR infructuous. Hmm. Hmm.
$17,900.
But this court in that proceeding was confined only to the show cause.
Yes, Lord. Yes, it's here.
So if there is any lacuna in the search and seizure reason to believe, then what would be your?
I can file appeal before under Article 226.
Now they are here.
No, see, that's a
Hmm.
proceeding.
Why opportunity was not given to you? It was a matter wherein you had appeared. I know, but during the pendency of the first writ petition, the second writ petition was filed, assailing the show cause. You yourself appeared, and thereafter the matter was taken forward. But unfortunately, those things were not brought. Be that as it may, this was the first point that you should have taken up. The petitioner has done it. We can't help it. But the revenue should have also, because this matter pertains to revenue. This is public money. So why was the revenue lapse occasioned on part of the revenue in handling this? No, that written argument should have been your first argument. Anyway, what has happened has happened. So, do you have anything to support, any ruling, any case law to support? This notice is again based on the reason to believe. Is it an annexure here? No. The reason to believe, is it also, that is a ground?
Main writ petition.
The main writ,
Main writ.
first writ petition.
No, that is the writ petition which is pending before me. No, okay.
Is annexed along with.
In the show cause notice, is there a reference to this Caesar? Where is it? I've seen it, but which paragraph? I know, which paragraph is this? Madam, where is that reason to believe that recording here in your writ petition?
That
It was done on 31/8/2017. No, the scissor was made on 31/8. Reason to believe is at page? .
31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. 31/8. petition.
35. Okay, yes. 19. Okay. Okay. Anything more, Mr.?
In my humble submission, not say the. Because held by the son of a. If they have any defect in the notice.
And your case submission is that the example given by Mr. Saikya with regard to a challenge to a FIR pending before the court, in the meanwhile a charge sheet filed. Where the law is settled that the FIR will not be rendered, the petition will not be rendered, infructors would have got no application.
There is opposition.
We are not going into that. Mr. Kail, if you want to have a discussion on that, when this court says that we are not going into that, if, he raised it, we have, I think your junior has briefed you, we have answered it also. So why create a ruckus when it is not required? You have pointed out your duty. You have done your thing within the parameters of law. That is enough. Anything beyond parameters, leave it out of this court. And if you start inviting me, then I'll have to come in. That may not be good for anyone, neither for me. So, Mr. L, we have spent much time in this institution. So we should know where to stop. Hmm.
In this case, what? The 29.
Not on one day. That was a result of your sheer casualness on the part of your department. Etu likha, her depart is at length. Eta khali date di dia weekdays or day itu mane motion date.
We file.
19 no na lage. A motion date dia. Third parties at length registered to list this matter on 22/9/2025 for delivery of orders. Yes. No, you will have to, because we are taking it very seriously. Hmm. Because we had this case notice was issued on 12/3. 10/4 time was taken. 25/6 time was taken. 31/7 time was taken. And this court also recorded that if the affidavit is not filed, we may proceed to consider. Then when the matter had come up, I was going through the matter. I found that the revenue's stand is very much required. However, the revenue is taking a very casual approach in the matter. Why? No, we have got it. This matter is of 12/3 and you are the custodian of the property, money. So if you start behaving in this matter, what would the public exchequer suffer? Because your explanation starts from 12/6, whereas notice in the matter was issued on 12/3. First date of adjournment is 10/4. Why? Why? But here I find him appearing very frequently. Whom did he inform the matter to? No, we don't want anybody to be unnecessarily harassed, but we want to know whom had he sent the notice to. That about the pendency of the matter, when did he send the notice? Because he received some instruction that day he placed before me. When was the first notice sent? When was it sent? Because normally when a matter is heard, directions are issued, you have to take the matter, inform the authorities. I want to know who he had informed the matter to and when. No need additional affidavit. I want the information. We'll have it tomorrow, day after. Mr. S.C. Cal, Learned Counsel for the petition. Mr. S.C. Cal, Learned Standing Counsel, CGST, has appeared in the matter in place of the earlier counsel who was conducting the proceedings. So, Mr. Cal has submitted that an affidavit in the matter has been placed on record, has been filed, explaining the reasons for the delay occasioning in filing of the affidavit on behalf of the respondents. A perusal of the said affidavit, more particularly the contentions raised in para 4, would go to show that the reasons for not filing the affidavit has been explained from 12/6/2025 onwards. However, it is seen that in the present case, notices were issued on 12/3/2025. Thereafter, the matter was listed on 10/4/2025. This court also on 10/4/2025 had, on the prayer of the Learned Counsel for the respondents, directed the matter to be fixed after the vacations. A further prayer was made on the next date of listing, that is on 25/6/2025, for further prayer was made by the Learned Counsel for the Learned Counsel for the respondents for further 4 weeks' time to file his response. Accordingly, the matter was directed to be listed on 31/7. On 31/7/2025, this court, noticing that in spite of repeated adjournments being granted in the matter, the affidavit was not filed, had granted as a last chance an opportunity to the respondents to file their affidavit on or before 18/8/2025 and had directed for listing of the matter on 26/8/2025. On 26/8/2025, when the matter was listed, the learned counsel appearing for the respondents had not highlighted before this court the reasons now set out in para 4 of the affidavit in opposition to be the reason for which there was delay occasioning in filing the affidavit on behalf of the respondents. Also, post with the above situation, Mr. Kyle submits that he would receive further instructions as to the date on which the respondents had received information about the pendency, the filing and pendency of the present proceedings. Registry to list this matter again on on 5/9/2025. Mr. Kayal, we know you. Your word is enough until and unless it's not disputed by somebody. I want to know how these proceedings are being done because these are revenue matters. If the petitioner has been wrongly harassed or the petitioner has been harassed, orders have been passed without jurisdiction, we are here. We will take care. But that will not be a ground for you to be lax in the matter. And these things, these repeated adjournments in revenue matters, we are not permitting. We are not accepting that because that is not on record before us. We don't know what your mechanics are. No, I am finding it irrespective of the council appearing. So GST matters, affidavits are not being filed promptly. Whereas you should be up and going in these matters. That I have seen it in the division bench, but where that submission is not there, still I find that the affidavits are not coming on record. Irrespective of the council appearing, this is my experience that the affidavits are not forthcoming easily. And I don't know why in revenue matters, this lax is being committed. Mr. Cal, rev up.
They're taking action against.
We are considering matter of public importance, public money involved. If the petitioners have been wrongly dealt with, we will come, we will protect them. But that at the same time, if the department is also found to be lax in the matter, we will proceed. Get me that, we'll see what can be done. Madam, it's for the betterment of all. Earlier conclusion of proceedings in your favor is also beneficial to you. Should not go. Okay. We're good.